St. Paul's Ask an Expert series is a free educational program featuring knowledgeable presenters from our community discussing meaningful topics of interest for older adults and their families.
Hello, I'm Dawn Hartman, the Director of Planned and Major Giving for St. Paul's Senior Living Community in Greenville, PA. Thank you for tuning in today for our virtual Ask an Expert program. Our featured community speaker joining us is Ty Cressman. Ty is an elder law and estate planning attorney based in Meadville, PA. So welcome, Ty. Thanks for joining us today.
I really appreciate the invite. Nice to see you, Dawn, and thanks to all of you listening today.
How you doing?
I'm doing well. It's the dog days of summer are upon us, and so days that make you want to lose the jacket and not wear a suit to work.
Yes. Well, today we're going to be talking about creating an estate plan that works. So, crucial topic, regardless of your age, whether you just started having kids, you have kids in college, you're getting close to retirement, we all need to think about our estate plan and get that put together. And Ty's going to tell us all about what we need to do that today. Now, I've been working with you for a few years where you have some clients that are St. Paul's residents, but for some folks who might be tuning in, this might be the first time they've seen you or heard your name. So let's talk a little bit about you first. Can you tell us just a little bit about yourself and your practice?
Well, I've been trying to create estate plans that work for about 12 years. I've been a lawyer in practice since 2008. I'm originally from Northwestern Pennsylvania. Always wanted to come back to Northwestern Pennsylvania. Interestingly enough, went to law school to be an estate planning attorney. And so I'm here by choice in all of those ways. My specialization is in elder law, which in some ways is a subset of estate planning, as we'll get into that distinction. I've owned my own firm here based in Meadville for about 10 years at this point, and over the years we've expanded. At this point we are 4 attorneys and 7 staff. We cover Erie County, Mercer County, Venango, Warren County, and Crawford County, obviously. And so it's an exciting area to practice in, and every day I feel very blessed to get to work with aging individuals, seniors, residents of St. Paul's, young people starting families, however their estate planning needs find us.
Wonderful. So estate planning, let's talk about that. What is estate planning? And how is that different from, you mentioned elder law. Can you kind of walk us through that for folks that aren't familiar?
That's one of the most common questions I get is, what is the difference between elder law and estate planning? Especially because many of us don't feel elderly, so why should we be worried about elder law? You can divide it up this way. Estate planning is primarily focused on what happens to your assets when you die, and also focused on what are the tax implications, what are the taxes associated with the passage of my assets upon my death. Elder law is much more concerned with how health affects our wealth, how a decline in health might affect the assets that I've accrued over my lifetime. I'm of the opinion that it's very hard in Northwestern Pennsylvania to do estate planning without having a pretty good elder law knowledge. The simple reason is we're all getting older, and as we get older, our health will change, and it becomes relevant to our estate plan to understand how that health is going to affect our wealth.
Right. Good explanation. I haven't heard it quite explained that way before, but thank you. So we're talking about creating an estate plan that works. How does someone in fact do that?
I think you can think about it in 3 simple ways. And even for clients who are trying to figure this out, we actually write these down during our conference. And so if you're watching this, if you wanted to write down the 3 most important things we cover when we talk about building an estate plan that works, the first is disposition. And we'll get to what that word means, but disposition. The second is taxes. What are the tax implications of death? And number 3, long-term care. How does long-term care affect the whole picture? Again, I think you have to contemplate long-term care in any sort of successful estate plan. But starting with disposition, that tends to be the one a lot of us focus on. I need a will, or I need an estate plan that gets my assets to the people I want them to go to when I die. Otherwise, my estate plan isn't very good. And so disposition is simply the art or the act or the process of making sure your assets pass to the right people in the right time upon your death. The taxes that we talk about are usually inheritance and estate taxes. How do my wishes, once we've established where or to whom I want my assets to go when I die, what are the tax implications of those desires, and how might we minimize or be the most optimal with our decisions to minimize taxes? And finally, long-term care. This is the X factor for many clients as we age. We don't know what the future holds with respect to our health care, but are we building estate plans that withstand the possible changes and healthcare needs we might have in the future? Let's talk about what the future is and what it could be, how it affects our plan, and making sure we're prepared for it. Sometimes it's just having a plan and seeing where the road goes. That's what a great estate plan looks like.
Right. And so let's talk a little bit more about dispositions that you mentioned first. That makes me think of the whole probate process, which some people hear that word and they think, oh gosh, probate is like a bad thing. Is it? Is probate bad, or is it a good thing?
So it's really neither. In a lot of ways, it could be good, could be bad. Maybe in some cases it's helpful to avoid probate. In some cases we actually need probate. And let me talk about disposition to kind of get us started through that question. Think about this, Dawn. It's really interesting. There's really, in my opinion, only 3 ways that you and I can own an asset. You can own an asset solely, just in your name. Mm-hmm. You can own it jointly with another person, say your spouse or even a child. Or you could own an asset that contains a beneficiary designation, like your life insurance or your IRA, right, or even a TOD, transfer on death account. Now again, if I were writing things down here, this would be something I would actually write down, because we do this with clients. We always start off with, let's list your assets, and let's then identify whether it's solely owned, jointly owned, or it's a beneficiary designated asset. We know that in almost all cases, so long as it is jointly owned between you and another individual, if you pass away, it's going to automatically pass to the joint owner. Right. In the case of beneficiary designated assets, those will pass automatically to the designated beneficiary. So it's only solely owned assets that are actually going to be impacted by your will. And it's only solely owned assets which are going to be subject to the probate process. And so we try and explain to clients and work with clients to figure out what, if any, assets we actually want to be subject to probate. And sometimes we do. If a client has a complex estate plan or complex desires, probate usually becomes necessary. In probate, I guess to answer the question directly, probate is really the process, the bureaucratic process of the administration of your assets when you die. It's confusing because it's used as both a noun sometimes as well as a verb in other contexts, like probate my mother's will, or I'm participating in the probate process. But really, it's the process of your executor administering a deceased person's solely owned assets. If a client is attuned to the difference between solely owned assets, jointly owned assets, and beneficiary designated assets, avoiding probate, if that is what they desire, is really pretty easy to achieve.
Okay. All right. So that's kind of talking a little bit about disposition. Do you want to move on to taxes? Taxes. Everybody loves to talk about taxes. What are the taxes clients should be most concerned about when they're creating their estate plan?
So this is another list of 3 that I would make if I was thinking through the applicable taxes when we die. 3 types of taxes: federal estate taxes, Pennsylvania inheritance taxes, and finally, income taxes to my beneficiaries. So federal estate taxes don't apply to most of us at the time being. there is an exemption amount that anyone who has less than about $11 million per person won't pay federal estate tax. So most of us, that's not a big risk. Now that amount is going to go down in 2026 to only $6 million a person. Still, probably most people in northwestern Pennsylvania won't be affected by federal estate tax, but we'll get to more on that because the law might change in the near future. Pennsylvania inheritance tax should apply to just about everyone. So, inheritance tax in Pennsylvania is based on the deceased person's relationship to the beneficiary. If it's a lineal descendant, child, or a grandchild, the inheritance tax is 4.5%. If it's a sibling, it's 12%. If it's a niece or nephew, it's 15%. And that's part of what we go through building a good estate plan, is knowing what those inheritance tax implications will be. Mm-hmm. The final piece of tax information that is critical to building a good estate plan is determining what the income tax consequences will be to the people to whom I'm leaving property. So specifically, IRAs are the kind of the big culprit here. IRAs, 401ks, those are generally pre-tax assets. And so income tax is going to be paid out when the beneficiary starts receiving distributions after death. And a good estate planning attorney should be able to walk a client through those rules. Also, your tax advisor or CPA could do a good job of that, and maybe a better job of that as well. But understanding the implications of the beneficiaries to whom I leave those assets. Also, knowing the impact of what is now known as step-up basis. If I gift an asset to a child to avoid inheritance tax of 4.5%, am I setting us up for a capital gains tax issue because I gave the asset away? Part of what we talk to clients about is picking, sometimes it's not avoiding all taxes, sometimes it's just picking the most minimal tax to work with.
Right.
And again, that's a good estate plan, the most minimal, the most optimal tax solution. Mm-hmm. That was a lot of tax in a short period of time, so we can return to that later on.
Yeah, there's way more, I'm sure, to tax.
Yes.
But yeah, that was a good overview, definitely. So the third piece you mentioned was the long-term care impacts that you need to be considering when you're creating your estate plan. How does long-term care fit into that whole process or picture of estate planning?
Long-term care, you can view it really two ways. The first of which is the potential need for long-term care can be the greatest disruptor to your wealth that we have, just due to the potential cost of long-term care. I would echo and on the heels of that say, it's also frankly one of the most important things that we ought to be saving for. Our long-term care and our long-term comfort and safety is worth using our money for. And so I think we spend a lot of time counseling clients on really two things. First of all, this is one of the better uses of our money, and the wealth that we have saved and accrued throughout our life can be useful in allowing us to chart our own course for what our long-term care looks like. And that's important to have that discussion, I think, pretty early on. I would say mid-60s to early 70s, so that clients can actually talk to children, family members about what their values are in terms of long-term care. The other side of that is at least knowing and understanding the role that public benefits play in how we pay for our care. We have a pretty robust public benefits system in our country, and it's worth understanding how we can leverage those public benefits to help us achieve the care that we need, because there is cost there. A good estate plan for a client makes sure that the right assets are going to the right people, that the taxes are minimized, but also that we have addressed really what the road forward looks like if the person's care or health declines over time. What kind of money we can privately pay for care, we can also utilize or leverage the existence of public benefits. And we really try to get clients out of the mindset. You hear sometimes people will say, well, I don't want the government to get all my money. I don't want the nursing home to get all of my money. And I appreciate those sentiments, but we try to provide some nuance to those sort of concepts of making sure sometimes that's actually the best use of our money. It's just how we choose that long-term care path to look like.
Yeah, very good. Now, suppose people are listening and they think, well, I've already done my estate plan. I don't really need to, this doesn't really apply to me.
Mm-hmm.
Once you do your estate plan, is that it? You're done? You don't have to worry about it again? Or should you be updating that from time to time? And what would trigger that?
It's a really good question, and it is a little bit different for all of us. Why would I update my estate plan? And certainly, there's a couple things we know for sure. If there's been a major life change, maybe someone named in my estate plan as executor has passed away, or they're no longer appropriate. Maybe someone who is a beneficiary has passed away, or they're no longer appropriate. Those are good life events. Maybe I get married, maybe a child is born. Those are always reasons to update an estate plan. I would say also that as we age, it is reasonable to expect that our different things will become important to us at different times. And so if we think of an estate plan merely through the lens of disposition, I want to make sure my assets go to the right people. It's possible the same will you have when you're 55 might be sufficient for your entire life.
Right.
But what I would encourage clients to look at a true estate plan is a little bit more holistic. A plan that not only gets the assets to the right people, but also incorporates a fundamental and good working knowledge of applicable and currently constantly changing tax laws, and also contemplates how a person's changing long-term care health affects that plan. Because of that, a good estate plan should be reviewed every 2, 3, 5 years as we age. At the very least, I would say, upon the death of a spouse, if someone is married, it's a really important time to get in and talk to an attorney. But I would say from age 65 on, I would be seeing the lawyer every 5 years or so, because those dynamics, again, the disposition might not change, but the tax laws almost surely will. And the impact of an individual client's long-term care needs will certainly change.
What do you think is the biggest estate planning opportunity that people miss?
I do think the situation where a loved one's health is changing significantly, and so I really wish, we could come up with age ranges. They're a little bit different for everyone, but let's say somewhere between the age of 65 to 75, or even 70 to 80, a client's first inpatient hospital admission with a discharge for rehabilitation services to a nursing home is a really good time to actually talk to a lawyer and say, I just had my first brush with the impact of long-term care on my wealth. Let me talk about what the road looks like going forward. For most of us, our first admission to a nursing home will not necessarily be our last. We may have an injury, we may need rehabilitation. I think that sometimes there's a sense to think of skilled nursing home care as the place people are going long term, but actually one of its most critical components is good rehabilitative care, which is good. And the nursing homes and the clients are largely on the same page. They want to provide top-notch rehabilitation services and get people back to home. The breakdown that I see happening is actually just as much health as it is sort of wealth and legal. People make that discharge to home and then kind of fumble the process of remaining successful at home. And that's one of those services. Again, we're very blessed in our area to have St. Paul's, among others, who have the ability not only to render that rehabilitative service, but offer home-based care that can follow clients home. In an ideal world, a client who had made that even brief nursing home admission, the client and the family would talk to a lawyer about putting together a plan where really they relied upon the services available, maybe looking at the impact of private wealth, public benefits, but the goal being of everyone, let's see what needs to take place to stay at home in a personal, dignified, independent setting as long as possible. That is my wish for all clients and families, is they get to age on their own terms. And I think that's where currently in 2021 the ball is being dropped, is that first inpatient admission and discharge home.
So we've mentioned the law a couple times. Tax codes change, the laws change. What changes in the law are you anticipating right now that are most affecting clients now?
So we had a really fundamental change in the tax law that took place just at the beginning of the COVID emergency, and so it passed under the radar. But Congress passed what is called the Secure Act of 2019, right at the end of the year. And the result was it fundamentally changed the taxation of IRAs, 401ks, and other qualified retirement assets. Now, it used to be if I left my IRA to a non-spouse beneficiary, that beneficiary could take only certain required minimum distributions over his or her lifetime. They could stretch that out over his or her lifetime. Now, for otherwise unqualified non-spousal beneficiaries, that is 10 years. So if I leave my IRA to my child, it's going to be 10 years, it has to be entirely distributed. So it accelerates that tax quite a bit. There are some important exceptions, the biggest of which applies to disabled children. Disabled children, or persons who are chronically ill, we can stretch out that 10-year period to a longer period, which is critical for disabled individuals who maybe we want to make sure we're protecting their public benefits long term. And so way too few clients, and maybe to some extent advisors, know of the importance of getting those, considering that as part of their estate plan. The upcoming legislation I'm watching very closely, and maybe many of you should too. We have two bills currently working their way through Congress. One is called the STEP Act. The other, I believe, is called the 98.5% Act, both of which fundamentally affect step-up tax basis or the federal estate tax exemption. Earlier you heard me say federal estate tax doesn't impact really anyone who has less than about $11 million overall. That's going to go down to $6 million or so. And again, there's $6 million in change in 2026. However, we may see that reduction take place even more aggressively and even sooner. I think the 98.5% Act that's working its way through was intended to reduce that to in the ballpark of $3.5 million per person or so. And so this is not a bad time as a result, if I'm in the several $million range, to be looking at my estate plan and actually seeing the extent to which it can be made flexible to ensure it can withstand those sort of legal changes. But obviously, every estate planning attorney is tracking those pretty closely to see what happens and see if anything changes before the end of the year.
Well, thank you so much, Ty, for joining us today. We kind of covered a good range of topics when it comes to creating your estate plan. We are going to share Ty's contact information on the screen. If you do have any questions or you'd like more information, he would be happy to talk with you about estate planning or any other elder law issues that you might be facing. We hope you enjoyed today's edition of Ask an Expert from St. Paul's Senior Living Community. You can check out all of our past episodes on St. Paul's YouTube channel or on our website. Thanks for tuning in.